information and responses you submit will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, Mr. Gomez. You may put your hand down. Mr. Gomez, you were charged with the offense of driving while intoxicated. It's the original charge. Before we proceed, I need to visit with you and talk to you about rights and protections that are afforded to you by the Constitution and statutes in Texas. You have the right to remain silent. That means you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit written papers that have your signature, especially papers that admit or confess to wrongdoing. That is the right to remain silent. Do you know you have that right?
Yes, sir.
You have the right to a jury trial. That means you and your attorney and the state could select 6 people to serve as jurors in your case. Those 6 would be selected from a pool of disinterested citizens who would hear all of the evidence, see and hear the witnesses and materials. They would decide or could decide if you're not guilty or if you've been proven guilty beyond reasonable doubt. That's called the right to a jury trial. You understand you have that right?
Yes, sir.
You also have the right to confront witnesses. That means if you decided to go to trial, the state would have to submit witnesses to try and prove your case. You and your attorney would have the right to question, cross-examine, or challenge any witness who would testify. That's called the right to confront witnesses. You understand you have that right?
Yes.
After this matter is concluded, you and your attorney would have the right to what's called appeal. Appeal essentially is demanding that a higher court review the official record, evidence, everything involving this case, and rule on whatever challenges you wanted to make. You'd have to be careful because it requires substance and information in the written documents, plus it requires obedience to time limitation. But it is essentially what is called the right to appeal. Do you understand you have that right?
Yes, sir.
Also, you have the right to demand that this proceeding be heard in the open public courtroom of County Court at Law Number 5. Because of the pandemic plague, we're not doing the open public hearings that we used to. But in order for you to proceed today, you have to consent to the video conferencing that we're doing by way of computers, etc. Have you in fact reviewed the document wherein you agree and sign a consent to proceed by video conference?
Yes, sir.
All right. Do you have any questions about the rights and things I have just talked about?
No, sir.
All right. Now, in order to proceed, you had to review and sign some documents regarding this case. Let's talk about one document is called Defendant's Waiver of Constitutional Rights and Court's Admonitions. Now, Ms. Kayleen Rivera just took down and is taking down the official record in this proceeding. The first thing she's done, or among the things she's done, is she's recorded that you yourself have agreed to and consented to the video conference. That's now in a written record. Also, the document that I'm talking about, Defendant's Waiver of Constitutional Rights and Court's Admonitions, that has a multitude of information, including a review of an acknowledgement by you of the rights and protections that you have been informed about and that you're giving up. Now, the document, it starts off by identifying you. All the documents identify you, and then you have signed them at the end. Did you have the help of your attorney,
Yes.
Liz Russell, in reviewing each document that you signed?
Yes, sir.
The documents that you signed, did you understand that?
Yes, sir.
Do you have any questions about those documents that have not been answered?
No, sir.
All right. Now, there's another document that identifies you, and then it is a certification by this court. It is titled Trial Court Certification of Defendant's Right of Appeal. That document tells you, I certified to you, that because you're participating in a plea agreement, you're giving up your right to appeal. Did you know and understand that?
Yes, sir.
Did you sign that document?
Yes, sir.
All right. Also, you're going to be granted probation. Did you read a document that's titled Application for Probation?
Yes.
Did you understand it?
Yes.
And you signed it?
Yes.
All right. Now, the state, do you have a motion?
Yes, Your Honor. At this time, the state would move to proceed solely on count 2, abandon count 1. Let me make sure that's right.
The original.
Sorry, this is an amendment. We would need to amend the information to add count 2 of obstruction, then waive count 1 and proceed on count 2.
Yes.
Mr. Gomez, what that means is the state originally charged you with driving while intoxicated, period. Now, what they're doing now is they are offering an amendment so that you can be charged instead with obstruction of a passageway, highway or waterway. Defense, is there any objection?
No, Your Honor.
And defense, do you waive the 10-day notice of amendment?
We do, Judge.
There being a motion with the appropriate action by the defense, the court grants the motion, and you're no longer charged with DWI. You're now charged with obstruction of a passageway, highway, or waterway, which is a different charge. Do you understand that, Mr. Gomez?
Yes, sir.
All right. Now, to the charge of obstruction of a passageway, highway, or waterway, how do you officially plead, sir?
No contest.
A no contest plea is considered a guilty plea in this court, and it's sufficient for me to convict you. You understand that?
Yes.
All right, I accept your plea. Did anyone threaten you, intimidate you, or promise you anything other than the plea bargain in exchange for your plea of no contest?
No, sir.
All right. Now, it is my understanding then that you're being granted deferred adjudication for how long? State?
Your Honor, the term of the probation is 14 months.
All right. I find there's sufficient evidence to find you guilty, but I do not. Instead, you're granted 14 months deferred adjudication. You will pay a $500 fine, of which $250 will be probated. You'll do 48 hours community service restitution. You'll do or complete the DWI education program, the victim impact panel, a TAP TAIP evaluation and recommendations. You'll have ignition interlock installed in your vehicle for no less than 7 months. Those 7 months will be continuous. You will, during the 14 months of deferred adjudication, you will not consume alcohol at all, nor any other illegal drugs. Is that understood?
Yes.
How do you make a living, sir?
I work for the city, sir.
And what do you do for the city?
I'm a parking attendant under Center City.
Under what?
Center City Development Operations,
Okay, and what are you paid by the city?
bi-weekly,
Yes, what do you get?
about 1,000.
So you're getting about 2,000 a month working for the city?
Yes, sir.
What is that hourly?
1644.
Doesn't sound right.
It depends on the time of day. I'm hitting the low bargain of it.
Mathematics is always there regardless of the time of day.
Yes, sir.
1644 times 40 equals 657 a week.
So, okay, my bad. About 12. Yes.
Times 4.33, which is the number of weeks in a month. You're getting 2847.40 a month. It's a significant difference from what you're telling me. Be careful what you do or say under
Yes,
oath.
sir. I'm sorry about that.
Judge,
Sorry.
I think he's probably referring to his take-home pay, which after insurance and taxes is closer to the $1,000 amount.
Okay. I hear what you're saying. All right. The $500 fine I approve. Do you have children you support?
No, sir.
No children.
Mm-mm.
All right. You are fined $500. I probate $250 in accordance with the state's agreement. But you will do 60 hours of community service, which means that I'm giving you a greater punishment than you agreed to. And under the law, if you want to, you can start all over again, but that's your choice. You will do the DWI education program in good faith, the victim impact panel. You'll submit to a TAP evaluation and recommendations. You'll have ignition interlock installed in your vehicle for 7 months continuously. You will not drive any other vehicle other than your vehicle that has the ignition interlock in it. Is that clear?
Yes, sir.
All right. Did you decide whether you want to accept the 60 hours instead of the 48, or you want to go start all over?
No, I agree to it, sir.
All right. Since we're being a little bit low on the fine, I want you to work a little extra. All right. Questions, state?
No, Your Honor.
The supervisory fee will be $29 a month. Mr. Gomez, you will not leave this hearing until you've met with Ms. Maricela Luna. She will start you off on the process for probation. The probation people are going to read to you your conditions. You're required to live up to 100% of the conditions as declared by the court. If you violate any of the conditions of this written legal binding agreement that you're doing, then the state will ask you to give you notice, bring you in for a hearing. And if that happens, and I think it's appropriate, I can revoke the jail, the 14-month jail term. What is that, by the way? How many days? Oh, this is deferred. I'm sorry.
Yes, it's deferred, Your Honor.
I apologize. Let me explain something to you, sir. You signed an application for deferred adjudication. Deferred adjudication is a written legal binding agreement between you and this court. And that agreement is, first of all, I did not find you guilty, although there's sufficient evidence to find you guilty. If you live up to 100% of the conditions of supervision, this case, the obstruction even will be dismissed and you're not convicted of it under Texas law. Violate the conditions and we have a hearing, then what happens is if the evidence is sufficient, and it better not be, if the evidence is sufficient, then I will enter a finding of guilt, a final conviction, which will follow you the rest of your life. And I'll be looking at the full range of punishment. A fine, $0 to $2,000, and jail, 0 days to 180 days. Is that very clear to you?
Yes, sir.
It better be. All right. Then I believe that concludes